Yes, Ron Poliquin, DoverLawOffice.com, your Delaware employment attorney. Today's subject is going to be, when should you see an attorney? How soon? The short answer is as soon as possible regarding employment cases, whether it be discrimination, whistleblower, wage and hour. First of all, there's just really harsh time restrictions. 300 days to file a charge of discrimination. Secondly, the best time is to start early. The consultation's always confidential, meaning just because you see an attorney and get information on the case doesn't mean that you're going to take action. But once you want to have the knowledge, you want to know what your rights are, know what you can do, and then once you get that knowledge, once you know your rights, then you can decide whether to act on it or not. It's your decision, not the attorney's. I always tell people, it's your life, it's your job. If you want me involved, I'll get involved. If you just want to know your rights and know that, that's the best way to go. You don't always have to act. Just because you can do something doesn't mean you should do something. And that's one of the parts of my job where I talk with my clients about strategic moves regarding their employment. Another issue that comes about is, how do you navigate employment law? There's a lot of times when the worst situation is when somebody comes to me too late, meaning they've either taken actions or not taken actions which have jeopardize their rights under the law. I would equate it to similar to a surgeon. You got a surgeon that comes in after a person has already botched their own after a botched surgery, and they're trying to fix it, or somebody's tried to put stitches on their own face. It's much easier for me to be in from the beginning and devise a strategy and a plan of action with that client, and then come afterwards after everything's already been done and try to fix things. Just on a legal sense, there are very specific defenses that an employer can raise later on if you did not go through the proper steps. A lot of companies have employment manuals. That employment manual may have or usually has some kind of procedure on how to report discrimination or retaliation and what steps to take. If you do not go through those steps, and you don't go through any of the steps, you've been discriminated the whole time, one of the defenses they may raise later on, and probably will raise, is that we didn't know about it. Okay, we just didn't know about it. I don't care if you say, hey, everybody in this company knew about it, it was common knowledge. If you do not go through their proper process, it could dismiss your case. It could, it could be a major issue in your case. So from the start, it's important for you to strategize with an attorney on how do we notify the employer, how do we protect your rights, how do we not jeopardize your status in a company, and how do we make sure that everyone is on notice of what's going on without hurting you as employment. Because I know as well as anyone that it is a sticky situation. Is a highly precarious situation when you are in an adverse setting with your boss, especially if it's a small company or a small company and you only have a few employees. That is not a predicament people want to be in. So we have to take all that into account and how we set up your case from the beginning while trying to protect your job at the same time. So you're going to want to navigate that. Need someone to help you navigate that maze of employment law. Another issue is you may go. There's going to be these HR people. Are the HR people really looking out for your best interests? Or are they just protecting the company? Especially if the harasser or the bad actor, the person discriminating against you, is the head of the company or your boss. Who's really HR going to be looking for? You got somebody getting paid $35,000 in HR. What kind of background do these people have? Do you have one HR person? Is there just some secretary handling the HR? That's a lot of times this happens in these small homegrown companies you have really no real HR department and nobody looking out for your rights. And even in larger companies, who's HR looking for? You need to have an advocate for you as an attorney, somebody in the background that can decide that you can trust wholeheartedly, because the only person whose communications are confidential are you and your attorney. Your communications with the HR or your statements to HR are not confidential. So HR is great, and we got to make sure you take the proper steps so the company remedies the situation and knows about it, but also a lot of times, let's not be naive, that doesn't happen. And I kind of touched on it before, but you also want to give the company, maybe there's an opportunity here to fix the situation. Maybe you're in a hostile work environment. Maybe there's a way to notify the company, have them address it properly, and then you go on and prosper in that company. A lot of times that's not possible, but it does happen. Maybe they do the right thing. Maybe a company or your employer does the right thing, and they should be given the opportunity to do that. So the issue here is that when you do not go see a qualified attorney early, you're really jeopardizing yourself in the future on what you don't know yet. So I'm not saying attorney is essential for everything, but certainly to see an attorney, have a consultation, at least know what your rights are, then you can take the proper steps from there. Thanks for the time. DoverLawOffice.com, Ron Poliquin. Thank you.